Thank you all for coming this morning. This is the eviction defense, how I handle an eviction proceeding. My name is Gail Murphy, and I'm the pro bono coordinator from the Volunteer Lawyers Project, and I welcome each and every one of you. Before we begin, I have a few housekeeping comments. One is that we are an accredited CLE provider. You are earning 2 hours of CLE credit today. You have to sign in, and you have to put the time. You need to remain for the entire program if you want to receive full CLE credit. VLP at this point in time does not provide partial credit. If you have to leave, I understand, but we won't be able to give you full credit for it. We also ask that you complete an evaluation form. That's the yellow piece of paper that's in the back of your materials. With respect to logistics, there's a bathroom in the front of the room, and there are men's rooms and women's rooms outside of this room. In the event of an emergency, there are stairs outside. I feel like, please make sure your cell phones are on silent or vibrate, unless you have a really splashy music that announces it, and that would be cool. We have a lot of information to pack in a 2-hour time period, and when I was talking with Grace, Grace and Jerry know when they're going to put a couple of short breaks in. And the other is, even though we say question and answers at the end, I believe that they can feel free to ask questions as we go along. I want to thank some people and some organizations. First, I really need to thank the Bar Association for letting us use this room. We are a project of the Bar Association, and they're so generous with us, and to that we are eternally grateful. I want to thank Grace Andriette and Jerry Chiari for their strong support of this program. I'm not quite sure how many times they've done this training, but they're terrific. I made a phone call. They said certainly. They put a lot of time and effort into it, and we really appreciate it. Judge Amadeo is going to be coming later in the program, and we really appreciate his support of us as well. My colleagues at VLP are tremendous. It's a full office effort to pull these things off. This is like the 3rd program I've done, and everybody is terrific. And I really also want to thank you for coming, for your support of the program, for learning a little bit more about eviction defense proceedings, and to learn a little bit more about pro bono. Has everybody received the materials electronically? They're huge. We have started, along with most of the bar associations, in providing the materials electronically. If you have any problems with that or questions, you have my email address, and please get in touch with me, and I'll try to fix up whatever snafus there may be. But in your materials, there is, first of all, a timed agenda, and there's also some selected handouts that we're going to be talking about this afternoon. I want to thank you because you're part of a very strong legal profession that has a really wonderful commitment to narrowing the access to justice gap. I don't know if you're aware, but Buffalo is the 3rd poorest city in the country, falling only behind Cleveland and Detroit. Buffalo has a 30.1% poverty rate. Our national poverty rate is 14.9%. And it's estimated that almost 78,000 people in the city of Buffalo live in poverty. That's huge. In 2013, Chief Judge Littman had a task force to expand civil legal services in New York State. And that task force report found that in 2010, 1.2 million low-income New Yorkers had at least 3 or more legal problems in a year. And at best, only 20% of those people have an attorney to assist them in civil legal matters involving the essentials of life, such as a roof over your head, food, healthcare, employment, family stability, and safety. This program was begun 24 years ago by our executive director, managing attorney, CEO, whatever he calls himself, Bob Alardo. It's his baby. It's a model nationwide, and we're so proud to still be able to support the program. In your materials, there are some statistics on the Attorney of the Morning program. It's the beautiful colored handout. It should be right at the top. The statistics are pretty impressive. Our Attorney of the Morning Administrator, Christine Sancioni, compiled those statistics. I think what's impressive about those statistics is, if you look at them, with the assistance of an attorney, almost all of our clients settled their cases. Nearly all of our clients were able to keep a roof over their head, or were able to buy additional time to get out. And those are really, really important. Because my time is limited to 5 minutes. Before we go into what CLE credits are and what the pro bono program is, I'd like to introduce Christine Sancioni to make a few comments.
Thank you all for coming. I am the Attorney of the Morning Coordinator. I'm the one who's going to be contacting you to sign up for a day. We do ask that you take 2 days. I do have my calendar here today, so if you have a minute to see me before you leave, I can sign you up. If not, I will be in touch with you. Thank you all for coming again.
Thanks, Christine. How many of you today currently volunteer for the Attorney of the Morning program? Put your hand up. Thank you. It's a great program. The first week I was at the office, I went over. It was incredible. What happened that day was we had a volunteer from Phillips Lytle, and Judge Amy Martocci was sitting on the bench, and her husband's a partner in the firm. So the associate that came out and said, "Gail, the judge wants to talk to you." So I went in and I'm thinking, the judge is going to say what a great program this is. The judge says, "Counselor, this attorney can't practice in front of me. Are you going to handle the cases?" I've been in the office maybe a week or two, and I've never done landlord-tenant law. To the credit of our profession, there were 2 landlord attorneys in the hallway. They saw that we were in trouble. They went right up to Christine and said, "How can we help?" With the assistance of those 2 attorneys, we were able to take absolute chaos and manage it and be very successful. That will stick in my head forever. In any event, one of the things that people are always interested in now is CLE credits. You get 1 CLE credit for every 2 hours that you provide pro bono legal services. That's been bumped up to what the prior rules were. It's all part of Chief Judge Littman's really strong effort to encourage pro bono service and to narrow the access to justice gap. You can also count up to 10 pro bono CLE credits toward your 24. How many newly admitted attorneys are in the room? Okay? You can't count your CLE credits for pro bono in your first reporting period, but you can carry over 6. And you can add that 6 to the 10 from your second reporting period. So if you're a newly admitted attorney, in that second reporting period, you can count 16 pro bono CLE credits. If you are an attorney emeritus, you can count 15 of your required 24. And that's on the court's website, and it's a tremendous program. We all know that there's an aspirational goal of 50 hours per year of pro bono service. That's Rule 6.1. Again, Chief Judge Littman has done a lot to support and encourage pro bono. It's kind of controversial, but he now makes the reporting of your pro bono service mandatory. So you have a voluntary service that is now mandatory. The goal is it will encourage everybody to provide more pro bono. But in any event, you have to report that. Law graduates who are admitted after January 1st, 2015 must provide 50 hours of pro bono service before they apply for admission to the bar. That's the CLE and pro bono. Limited scope, very quickly. Attorney of the Morning program is a limited scope program. It means that when you meet your client, your engagement begins. When you finish serving your client that day, your engagement ends. That is limited scope. You are only that person's attorney for the time that you're working with them in the courthouse. For those of you, well, you're all practicing, and you all know that you have all kinds of conflicts requirements that you have to comply with within your firm. Rule 6.5 relaxes all that formal compliance because, again, we want to encourage pro bono service. So, you're only required to comply with those formal conflict rules only if you have actual knowledge that a conflict exists when you meet with that person. That rule doesn't require you to call your office manager to say, "I'm representing Joe Smith. Would you please see if we've ever represented him or any party that's adverse to Joe?" So all you need is actual knowledge. The comments sort of explain a little bit about that, but it becomes a little murky. And the attorney volunteers who have been working with us were really concerned about that. And so what Bob Alardo did with some committee members from the State Bar is that they wrote to the New York State Ethics Committee and they said, what happens to a lawyer's conflict? What happens with respect to conflict with a lawyer who provides limited scope representation? It's really not clear. In your materials, there's opinion 1012, and it's fabulous. It answered every single question that every single volunteer has ever asked us. The bottom line is there were two questions that were asked. One was, do the usual conflict rules apply to a lawyer who participates in limited pro bono programs after their representation ends? And if there is a conflict that's found out, is that conflict then imputed to the firm? I'm just going to read you the conclusion because it is a 5-page document. It's incredible. If you like ethics, it's great. The conclusion is, a lawyer who has represented a client in a limited pro bono legal services program is prohibited from subsequently representing a materially adverse client in the same or substantially related manner only if the lawyer has actual knowledge of the conflict. Even if the lawyer has actual knowledge of such conflict, however, the conflict is not imputed to others in the lawyer's firm. Whether or not anyone in the firm represents a client adverse to the limited services client, the lawyer who represented the limited services client remains bound by confidentiality obligations to that client. So we're very hopeful that this is putting to rest a lot of the concerns that general counsel and all the firms have when their associates and partners are going out and participating in our limited scope programs. That being said, now we're on to the good stuff. I want to introduce to you, and I'm just thrilled that we've got them here again today. Grace Andriette is the supervising attorney of the housing unit at Neighborhood Legal Services. She has just volumes of experience. She speaks at Bar Association seminars. She's a very good friend of VLP. She's on all kinds of landlord-tenant associations, and she's certified as a real estate instructor. Wow. She serves on a lot of boards, and she's from Cornell, and a UB Law graduate as well, right? And while I'm at introductions, Jerry Chihari is a partner in the firm of Chihari & Alecki. He represents primarily commercial and residential landlords in Western New York. So they're a great team together. You're going to have fun. He also has a practice involved in commercial and retail collection, real estate, misdemeanor criminal law, and general civil litigation. He too has a resume that speaks volumes. He's very active in bar associations. He's a frequent lecturer for all kinds of seminars. And he is a recipient of our Pro Bono Award for his work representing our indigent clients in Western New York. That being said, thank you and welcome.
So good afternoon, everyone. Thank you for being here. And I just wanted to thank Gail Murphy and the staff at the Volunteer Lawyers Project just for being wonderful partners and for assisting us in representing the low-income community here in Buffalo. So my name is Grace Andriette. We really have a whole lot to cover today, so I'm going to talk really fast, and you just have to write notes really quickly. That's the sort of sense that you're going to get when you're an attorney of the morning, especially when you see a lot of people, potential clients in the hallway. And I think sort of resisting the impulse to race through your client interviews as quickly as possible is something you have to consider. At the same time, though, you have to balance the fact that the court is anxious to get off the bench. The landlord's attorneys who are sitting in the hallway are anxious to get back to their offices. And it's a time-limited program. So I teach a course up at UB, and we talk about client interview techniques. And we show these sort of ideal interview settings where you bring someone into your law office and you offer them coffee and water. That's not, unfortunately, going to be the work environment that you'll find yourself when you're providing assistance through the Attorney of the Morning program. Your negotiations are going to take place in the hallway. Your client interviews are going to be taking place in the hallway. Hopefully you'll have a place to sit while you're doing this, but none of this is guaranteed. But you do have to be careful that even though the environment is sometimes a little less than ideal, that you're really doing everything you need to make your client understand what they're looking at. And that involves how long might it take before that person, your client, might be evicted. What's the likelihood of success? What are your client's options? Hopefully after today you're going to know way more about the eviction proceeding than your client does. Sometimes you're going to have a client who's been through the process before. I would say when I'm over at City Court, the majority of my clients have not been through the eviction process before, or if they have, it's been several years ago. So they might have had a different experience when they went to court last time than what's going to happen in court today. So maybe their landlord in the prior eviction was very easy to work with, they had a good relationship with that landlord, and today's landlord, today's petitioner, just wants them out immediately. So talking to your client really early on about what could happen, I think, is very important. And the reason for this is that many clients walk into court with a sense of how long they might have before they're actually put out that's not based in either reality or in law. So that's information that you really have to share with your client early on. And I don't suggest that you need to be sort of the conveyor of bad news early on. You know, you don't want your client to think that you're not going to be a zealous advocate. So if you look at the papers and say, you know, you could be put out in 72 hours before you even talk to your client about the case, your client's going to think, what kind of an advocate are you anyway? But I think it's important to be sensitive and to also let your clients know you could win, you could lose, or we could settle this case. If we win the case, then most likely that means that the petition will be dismissed, your landlord could file again, you could find yourself in court in a week. If we lose the case, however, you could be evicted in a week. And if we settle, maybe we can achieve something that will meet your needs. And I find that by starting with that information, I give my client a sense of reality. Those things are all true. B, I also set my client's expectations at a reasonable level. Many people walk into court and think, oh, if I'm pregnant, I'm going to get extra time. Oh, I'm a person with a disability, I get an extra 30 days. Oh, no one gets put out in the first appearance, or right after the first appearance, there's always an adjournment. These things are not true. You know, I've literally had clients who have checked themselves out of the hospital, come to court, and then have been evicted within, the state law says 72 hours. In reality, it takes, I would say, generally a week in the city of Buffalo before the Buffalo City Court marshals come and put people out. So it's a very quick process. So I guess the first piece of advice I have in terms of settlement negotiations is when you're talking to your client, just make sure that your client is aware of what the worst case scenario is. And I would, you have to do what your client gives you authority to do. But I would always suggest to the client that I have a conversation with the landlord or the landlord's attorney. And why? Well, first, it's an opportunity for free discovery. You're going to get a lot of information from having a conversation with the landlord's attorney. Maybe your client just needs extra time to move, and the landlord or the landlord's attorney is fine with that. They're in no particular rush to have your client put out. That makes the case very easy. You may not have to get prepared for a hearing or be prepared to make an argument before the judge. Now, having said that, don't go and talk to the other side too early in your discussion, because you want to know if you have any defenses. And it makes sense when you're talking to the other side to know what those defenses might be, because the tenor of your negotiation with the landlord's attorney or with the landlord is going to be different if you start the conversation with, I think I might be able to get this case dismissed, or we're going to move for dismissal. However, my client is just looking for 2 weeks to move. If you start the conversation with, my client needs 2 weeks, you might not get to an agreement as quickly. So talking to your client about talking to the other side always makes sense. You're going to find out if the other side's sort of perception of the facts or rendition of the facts is significantly different than what your client just told you. You're going to find out what the landlord's position is. Your client may tell you that they never got served with certain notices, and we'll talk a little bit more about what those notices are. But your client may say, oh, I never got what's called a pay or quit notice. And so you might mention that to the other side's attorney, and they'll say, oh, well, here's the pay or quit notice, and here's the affidavit of service. It doesn't mean that it was in fact served, but then you know that when you go before the court and you say, my client was never served with these required notices, that the landlord's attorney is going to say, oh, yes, they were, and here's the affidavit of service. So it gives you a little bit more information. You're better prepared if the case does end up going before the judge. So I'm going to speak a little bit from this document called Settlement Negotiations, which I think is included in your materials. Take cases where the landlord is represented by an attorney first. Jerry Chiari has been a volunteer, an award-winning volunteer for the Volunteer Lawyers Project, but more typically he's in court representing landlords, and he can tell you that when he has to wait around all morning, he may in fact be less open to settlement agreements.
Really?
By the time it gets to be 10 of 12, then he may be at 9:30 in the morning. So not only is it sort of an act of courtesy, you may also find that your negotiations go smoother if you're not working with an opposing attorney who's been there a little too long.
Great. You might want to just do a little housekeeping.
Oh, sure.
Questions, they're free to figure questions if they want.
Please feel free to interrupt us if you have any questions or if we're not clear. And I don't mean to be rude, I'm just checking my cell phone to make sure I don't talk too long. Always try to talk to your client in an area away from others. Even though you are interviewing your client in an environment that is not at all a law office, you still want to try to maintain confidentiality as much as possible. This says, is the tenant possibly eligible for HPRP funds? This is a little bit older, we should have updated that. But we'll talk later about the types of emergency assistance that might be available. And you want to consider that if you're representing a tenant in a non-payment action, you might want to know what kinds of emergency assistance is available. This says, how much time does the tenant need to move? I don't think you have to start your interview with the client with the assumption that they are in fact moving. As Gail mentioned earlier, most of these agreements, or most of these eviction cases are worked out through an agreement, and many of those agreements allow the tenancy to continue. But you might want to talk to your client about the fact that if they're unsuccessful in the defenses that they raise, so let me step back. So you're in front of the judge, you're making your argument, and suddenly you just have that sort of sinking feeling that you're not going to win this case. At that point, you might want to say to the judge, Your Honor, my client only needs 2 weeks to get out. So you found that out from your client, even though that's not what they wanted. They wanted to continue their tenancy. You spoke to the other side. They weren't willing to give your client 2 weeks to get out. But you know that 2 weeks is kind of the bottom line. They'd like to stay, but 2 weeks would work. If you feel like your ship is rapidly sinking, that might be a time to say to the judge, Judge, could we just get 2 weeks? And it really depends on the judge you're in front of. There are 12 city court judges, soon to be 13. Not all of them rotate through special term, but there's 13 very distinct personalities, and I can't say 13 completely different views of what the landlord-tenant law requires, but there's some differences there. So a defense that might work in front of one judge may not work in front of another judge. An appeal for more time in front of one judge might be greeted as a way to resolve the issue in a way that's positive for both parties. Other judges, their position is, if you didn't pay the rent, then you've got to go. The law says 72 hours. You're going to get a week just because of how the process works, and a week is plenty of time. So at least knowing sort of what your client's bottom line is might help you get closer to what they're looking for. Always talk to the landlord or the landlord's attorney in an area where your client cannot hear the conversation. I've made the mistake, I don't do it anymore, but I'll sort of persuade my client that a certain outcome would be a positive outcome. Now, when I say persuade, you're not trying to talk people into doing things that they don't want to do, but you probably know the reality of your client's situation. perhaps, not in all regards, but legally better than your client may. So while your client may think that things happened that should require an automatic dismissal of the petition, you may have the sense that you're not going to win. But you talk to your client and you've come to an agreement or an understanding with your client about what you'll be asking for when you negotiate with the other side. And then you walk over to the landlord and the landlord starts calling your client names and your client hears this. Well, then all deals are off, you know. Your client may want their day in court, they might want to go in front of the judge, which you're clearly obligated to do. That might not result in the best outcome for your case. So keeping the parties separated prevents those sort of unfortunate situations from coming to the fore. And the opposite happens. You know, you may go back to your client with something that the landlord has suggested, and they get very angry, and the landlord hears it, and the deal gets sort of scuttled. So be careful about keeping people separated. Don't make promises your client can't keep. So the negotiation process can be fairly protracted. You know, you don't want it to go on forever, but you may find yourself, wear comfortable shoes, you may find yourself going up and down the hall talking to your client, talking to the landlord or the landlord's attorney. And after, you know, 3 of those trips, the landlord's attorney may ask for something that you think is completely reasonable. Make sure you have your client's authority to say yes to anything that the landlord suggests. And why is that? It's really hard to go back in a negotiation. You know, if you're the landlord's attorney and you say, I just need them to let me in tomorrow at 5 because I'm showing the apartment to a prospective new tenant, and you say, oh, that sounds reasonable, that's not going to be a problem, I'll recommend that to my client. And then you go back to your client and your client says, no, I work from 4 to 11, I'm not home at 5, my 13-year-old's home alone and I don't want the landlord coming into the house when I'm not there. If you left the landlord or the landlord's attorney with the impression that that was not going to be a problem, and now you have to go back and say, well, that's not going to work, suddenly you may find yourself 2 steps back in your negotiation process. So anytime the landlord suggests something additional or your client suggests something additional, you want to be checking back with the other side before you make comments, sort of judgments about, oh, yeah, that's not going to be a problem, or I'm sure we can agree to that. Don't agree unless you know you have authority to agree. I think we'll talk about drafting settlement agreements a little bit later. So, but things to keep in mind, at least when you're talking to your client. If there's a lot of animosity between the landlord and the tenant, and there's a repayment plan that you've negotiated, you may have to be very specific about how that payment is going to be made. Some landlords enter into repayment plans that they really don't want to enter. If there's an attorney on this other side, the landlord's attorney may insist that all payments go to his or her office. And in some ways that makes life easier because you know it's a business office, it will be open from 9 to 5. If the tenant says, oh, my landlord always comes to collect the rent, you want to be clear that that's how the payment is going to be made. You may even want to suggest some sort of alternative payment that offers more assurance that you can prove that it wasn't that the tenant wasn't home, it was the landlord didn't come, that the landlord didn't come. It's easier for the folks at Neighborhood Legal Services to do that because I can tell the client, let's say, to pay the rent to my office and we can send a check out to the landlord. You're not going to have that ability, but you may want to think about the fact, especially if this is a landlord-tenant relationship that has disintegrated, you may want to think about the fact that the landlord may use non-payment as the basis for getting the warrant of eviction, putting the tenant out. And if you haven't been clear on how that payment's going to be made, and the landlord simply doesn't show up, then your client is going to end up having to go back to court trying to stop the eviction on a very sort of time-limited basis. So try to be specific about those payments. Also talk to your client about kind of the realities of, or the likelihood of your client having money on the day they said that they would have money. So this is sort of a typical conversation I have with my clients. My client says, I'm going to get paid on Friday so I can pay the landlord's attorney on Friday. So I say, oh, well, what time do you get out of work? I get out of work at 7. The landlord's attorney's office closes at 5, so maybe we need to make that a Monday payment or a Tuesday payment. What time do you get ask a question or two, because it's very easy to write rent to be paid on Friday to landlord's attorney's office. And if your client goes knocking at the door at 6 o'clock, there's a very good chance that the landlord's attorney has already set the wheels in motion to purchase the warrant of eviction, the paperwork they need to put the tenant out. So, find out if your client's someone who works, whether in fact they're going to have the money in time, in a form that they can pay it. They're not going to be able to take their paycheck and run it over to the landlord's attorney's office. That's going to have to be cashed and so forth. Your clients also want to tell you what you want to hear sometimes. So if your client seems to be a person without means and they're going to make a $1,000 payment in 2 weeks, I think it's appropriate to say, are you sure you're going to be able to get that money? And if they say, well, I get my check from the Department of Social Services on the 15th and I'm going to borrow some money from my brother, then maybe you want to split those payments into 2. So there's one payment on the 15th and one payment later in the month. Your clients are people who are poor, and usually the reason why they're in court for non-payment of rent is because they've lost hours at work, maybe they've been sanctioned from the Department of Social Services, maybe they've misspent their very limited funds. So be a little wary of promises to pay large amounts of money in a short amount of time. It makes sense to at least talk to your client about whether that's reasonable. So I know that because Jerry often approaches this from the landlord's perspective, he has certain pet peeves about how at least the attorneys at Neighborhood Legal Services start the negotiation process. So maybe we can hear from Jerry on what works and doesn't work in that realm.
We're going to put this online. I'm going to hold up a code for the online viewers. If you could just read it out for me. I put a paper on your...
We're doing what?
Oh, okay.
When they watch this thing.
The code is HCLE3X, HCLE3X.
It's a different introduction than I usually have. But anyway, hello. I always like to do seminars with Grace because much like when we're in court together, she does all the talking. So I will have a limited role here. I have to put on my other hat, which is the tenant representation hat. Normally I wear the what Grace calls the bad guy hat, and I call the good guy hat, and that's I represent landlords. As makes up most of my practice. But what we're talking about now is really sort of universal for the landlord side and the tenant side. And it's really not that hard to flip-flop. One of the things, though, the first thing I'm going to tell you is a very practical thing. And the very practical thing is, don't approach the other side with this sense of righteous indignation. That's going to get you absolutely nowhere if we're talking about negotiation. It may get you somewhere with a judge. If you're arguing your case in front of the judge and you want to be as zealous of an advocate as possible, you may score a lot of points with that. You won't score any with the landlord's attorney. They think, by and large, that your client is absolutely wrong and is cheating the system, quote unquote. So with that in mind, approach it from a different standpoint. Approach it from the standpoint of, we're here to reach common ground. We're not here to tell you that your client is a bad guy or an evil guy or a non-caring landlord. We're here to just simply resolve the issue and not be very judgmental on the other side. Now you may face a landlord or a landlord's attorney who doesn't see that the same way, and they're not looking at it the same way. Your job really, if you're going to try to service your client as best as possible, is to convince them that it's best for everyone to reach a mutually acceptable agreement. So with that in mind, there's a couple things that you want to consider. The first one that we always look at when I represent tenants is that evaluate what kind of service was made upon your client. And once you see whether or not the service was made by personal service or by substituted service, You can make an evaluation as to whether or not it may best serve the interest of your client simply to not have them appear. We call it walking the tenant. And when that's the most beneficial situation for your client, let's say, for example, that they really can't pay on a non-payment case, they can't pay the rent, or in a holdover case, they have been properly served with a notice to quit, to vacate. And they really have very few defenses, but in a non-payment case, you don't want them to be subjected, at least in this particular instance, to the entry of a money judgment against them. So in that case, if there was substituted service, and if you are talking to them in the hall, the court does not consider signing in with the clerk an appearance. They do not consider it an appearance until you actually walk up in front of the judge to be heard. So your client hasn't made an appearance, they haven't appeared, they haven't submitted to the jurisdiction of the court, therefore they are not subject to a money judgment at this time. And many landlords just want their property back, and they will not pursue in a separate forum the money judgment. So it may well behoove you to advise your client, simply turn around and get back on the elevator and walk out. We will notify the court that you are not appearing, and a money judgment will not be entered against you. A warrant of eviction will, but you'll have X amount of days to in fact vacate. Is there a question?
Is there any sanctions against them for not appearing?
No, there is not. They cannot appear. The only sanctions, if you want to term a warrant of eviction or a possible money judgment, because if they were served personally. In some jurisdictions, Grace and I just had this conversation. In some jurisdictions, serving a tenant with due diligence will confer personal jurisdiction upon them, and they will be able to get a money judgment. I can tell you right now that there's not a judge in city court that I've witnessed since Judge Nowak has left city court, and it's what, 2 or 3 years?
It's been a while now.
Yeah. That will grant a money judgment based upon any form of substituted service. So you could be fairly confident, although you have to be cautious. Grace and I talked about this earlier as well. You have to be cautious because there is case law out there that, especially if there's an attorney on the other side, that if they want to make an argument for a money judgment, that they may be able to prevail, although I don't think in city court they will. Now, one of the things you should also remember is that you may want to discuss that point with the other attorney before you walk your client, before you advise them simply not to appear. You may want to say, if I turn my client around and you get your warrant, are you going to look for a money judgment? And most of the landlord attorneys that I know are well aware that it's a very uphill battle in city court today to get a money judgment on substituted service. There were questions back here. Let's start there.
Some tenants ask if the eviction goes on their record and if it affects their future prospects of getting housing.
That's Grace's question. Can you
Sure.
respond to that?
So, yes, it goes on their record in several ways. If there's a money judgment, certainly that's going to impact credit reports and the like. Second, there are agencies that do searches, and so they'll search the city court records or other court records to see whether an eviction proceeding has ever been initiated against a certain tenant, maybe as part of a tenant application process. And so, yes, the fact that the eviction was filed against the tenant, that's going to be part of the public record, and there's nothing the tenant can really do to change that. Even if the case is dismissed, there's still going to be evidence of a filing. Third, for tenants who live in public and subsidized housing, so there's a lot of terminology around this, but they may have a housing choice voucher, or they may live in a development that's subsidized. When they apply for a subsidized housing opportunity in the future, that subsidized housing provider may ask and then may check to see if there's ever been an eviction from another subsidized landlord. And the fact that there has been and there's money owed may preclude the tenant or the individual from being able to rent subsidized housing in the future. And finally, you as pro bono attorneys through the Volunteer Lawyers Project are not likely to be handling cases that involve public and subsidized housing. Those cases generally are adjourned to a Tuesday or a Thursday when Neighborhood Legal Services is there. But for people who are on the Housing Choice Voucher or the Section 8 program, if they're evicted, that's a basis for termination from the Housing Choice Voucher program. And that program is worth a lot. It pays a substantial portion in some instances of the tenant's rent. So getting thrown off that program can be a real economic problem, for a financial problem for many people.
I told you Grace talks a lot
I
more than
talk
I
too
do.
much, I'm sorry.
In any event, my answer was simply I don't know, and hers was much longer. But there was another question back here.
Just with regard to service, so it's personal service needs to be affected in order to trigger a required appearance, and then from there, potentially a money judgment if the person doesn't appear?
Not quite. Personal service needs to be affected in order to obtain in personam jurisdiction to get a money judgment. With the qualifications we just talked about earlier. That's not exactly the same. You can have substituted service. It's a perfectly valid way to commence a proceeding. And once the tenant appears before the bench, now they've subjected themselves to the possibility of a money judgment.
So what's the recourse then if you have substituted service and the defendant continues to walk, then what would be the recourse for the landlord?
For the landlord,
Yeah.
in terms of the money judgment,
Right.
they would have to pursue it in a separate forum. They could either sue city court, bring a small claims action, depending on the size. I think the small claims jurisdiction is $5,000 in the city of Buffalo. So they could pursue it if they chose. I can only tell you from my landlord attorney experience, about a little more than half of my clients pursue money judgments. It's right around 50-50. Some just are happy to get their property back, cut their losses. Others will go after the tenants for the money judgment.
Thank you.
Sir.
What is a substituted service?
Substituted service, and we'll get into that in a touch when we cover defenses, but if you, it's a little bit different. The CPLR differs a little bit from the RPAPL. The RPAPL, it's section 735, which outlines the service, and substituted service is one of several things. Personal service, of course, is handing it directly to the respondent. Substituted service is either nail and mail or suitable agent discretion. There are publication, but that's very seldom used in a landlord-tenant proceeding. But the nail and mail, landlords don't like to nail things anymore into their own property, so it's tape and mail. But it is 735 service is very important in our discussion today, more important when we get to defenses. But what it is if you nail and mail, you have to affix to the door after reasonable application. Reasonable application is generally, the way I read the cases, 2 attempts. Due diligence, on the other hand, that CPLR requirement, is generally 3 attempts at varying times. That's one type of service, and nail and mail has to be followed within 24 hours, a mailing both by regular mail and by certified mail. Again, very important when we get to defenses. That is pretty much the same as if you serve suitable agent discretion. The discretion is a little bit more important than the age. It's a subjective thing, case by case. Judges will, if you're in a traverse hearing, which is a hearing having to do with service, if you're involved with that, and the judge feels that the 10-year-old had a suitable discretion to be able to know that he had to give this to mommy or give this to daddy, then they will uphold it. generally the ages are around 12 years old, 11 or 12 years old, that the court will say you can serve them by this substituted method. This method too, though, has to be followed within 24 hours with a mailing, both certified or registered, and by regular mail. If it's not made by both, it's not valid. Are you timing this here?
I am not, but we're probably,
But just yell at me when you're good at that too.
we're probably close.
The attorney's fees, just remember that if somebody is seeking attorney's fees in their application in a non-payment proceeding, they're automatically reciprocal pursuant to the RPL, and that's a negotiating tool because you can talk to the landlord or the landlord's attorney, or it would be the landlord's attorney in this case. You can't seek attorney's fees if you don't have an attorney. But if an attorney is seeking attorney's fees as something that was contained in the lease, you might be well to remind them that should you win the case as an advocate for the respondent, that you may apply for attorney's fees as well. And apparently they're able to be granted even though you're not being paid. So the tenant, now I don't know exactly where that money would go if you were awarded attorney's fees, but
It would come to our office.
but it would come to the attorney of the morning office? Or?
Oh, yeah, Volunteer Lawyers Project probably can.
We encourage our pro bono attorneys, if attorney's fees are part of the relief, that certainly they can ask for it. And again, it's been told that that's a huge negotiating tool.
Right. It's very important because where someone may think they have nothing to lose other than not obtaining the warrant, should you be successful in defending your client and there was an attorney fee request, you may be successful in a reciprocal attorney fee request to the judge. So that becomes a negotiating tool, as does cost and disbursements and things like that they may be seeking, and you may be able to say, use everything that they're seeking as a possible negotiation. If they're seeking attorney's fees, costs, and disbursements, and you're trying to work out a settlement agreement, a repayment agreement for your client, try to get them to reduce the attorney's fees, try to get them to, don't quote me on that, try to get them to reduce the costs or combine the costs with the attorney's fees, something like that. So it reduces the burden, the ultimate burden on your client. The warrant date, the warrant execution date, there's two things about a warrant. The warrant issues when the judge actually signs it and issues it. The warrant executes when the marshal actually puts the people out. So the date here can be a negotiating tool, but Grace wanted to talk about that later in her discussion, so I'll just skip over that for now. And lastly, I would just say look to your client's defenses, whether they're strong, medium, or weak. And quite frankly, even if you have weak defenses, they may be able to be used as a bargaining chip in either convincing the other side to enter into a repayment agreement or convincing the other side possibly to give your client more time in which to vacate. Just the threat of going to trial, very few of the trials are conducted on the spot. The threat of going to trial means that the judge would set a date somewhere in the future for the actual hearing. You may request discovery. If you request discovery, just know that you don't have an absolute right to discovery. Discovery is in the discretion of the court and can be limited by the court. And if the court thinks you're using it only to buy time, they're not real happy with you. But just the threats of those things may get you to buy your client a little bit more time if that's what they're looking for, by talking to the other counsel and saying, look, we'd rather not go to trial here. All we really need is another 10 days, and we're going to get that if we end up going to trial anyway. And this is the easier way for both sides. That's generally very effective And lastly, sometimes if your client just needs an extra few days, you may be able to buy it. Whereas your client may owe $2,500 in back rent, but needs till the end of the month in order to vacate and have their new apartment ready, you may be able to offer a small portion of the arrearage just to get to the end of the month. And oftentimes, landlords and landlords' attorneys will accept that just to get a little something out of the proceeding and have a date certain when the tenant is going to leave.
So a quick war story on what not to do. It was Christmas time, and I had a really sympathetic eviction, and my client had negotiated a repayment plan, but she couldn't meet it. So I called Jerry and I asked him if we could work out an arrangement. He says, no, I don't have any authority to change the agreement. And I say, oh, please, it's Christmas. No, I don't have any authority to change the agreement. So finally, out of complete frustration, I say, you just want a bigger Christmas tree. That's why you won't negotiate on the attorney's fees. And there's this pregnant pause, and he sort of sighs and says, Grace, do what you got to do. So, arguing about opposing counsel's attorney's fees when you already have a stip, it's going to be an uphill battle. So I'm going to start with a quick glossary of terms, just so you have a better understanding of what we're talking about. So a summary proceeding is a special proceeding under Article 4 of the CPLR. And it's an expedited proceeding. So unlike plenary proceedings, the courts, in most instances, are very picky that the I's are dotted and the T's are dotted, and will not generally allow the petitioner leave to amend their pleadings if the pleadings are incorrect. So it's a little different from other types of law you may have practiced or other cases that you may have litigated. So there's a petitioner, the landlord, and there's a respondent. And what the petitioner is usually seeking is a judgment of possession. They want the property back. And they also typically want a money judgment, although not in every case. Clearly in a non-payment case they do, and in a holdover where they're just, maybe the rent has been paid, and Jerry will get into these terms a little more. The rent has been paid, but the lease has been violated, let's say. It may be that the landlord only wants the judgment of possession, and they're not seeking a money judgment. The warrant of eviction is the document that the landlord gets to dispossess the tenant. As Jerry mentioned, the warrant is issued by the court, and it's executed by a civil officer. So a civil officer, and that could be in Buffalo City Court, it will be the Buffalo City Court Marshal's office, will come and knock on the door, tell the landlord that he or she has the right to change the locks, and if there's any resistance on the part of the tenant, that won't last long, and the tenant will be escorted from the premises. I haven't heard of cases of arrest, but I'm sure that they have those powers.
In suburban evictions that I've done, I've had some arrests, but I've never had one with Buffalo City Court Marshal. I've had them with the constables in the towns where they have to call the police. The people the constables won't. Marshals, I think, will physically escort them out. The constables generally will not, and they'll call the local police. They'll show them the warrant, and then the local police will escort them out. If they resist in any way, then generally it's a disorderly conduct arrest.
And the tenant, the respondent, does not have a whole lot of time to leave when the marshal or the civil officer comes knocking at their door. So I've actually had people come to my office in bedroom slippers after they've been put out. I think the marshal, I've not been there, I should go one day. I think the marshal gives the tenant a little bit of time to gather possessions, but it is not a lot of time. Under state law, the tenant has 72 hours from the time that they're served with the warrant. Weekends don't count, and as I said earlier, the Buffalo City Marshals are overworked, so it takes about a week before they actually come to dispossess the tenant. But if you're practicing in the towns, some of the towns, Cheektowaga, Tonawanda, have hired their own civil officer, and they pretty much stick to 72 hours. So if the warrant is served on Monday at 7, Tuesday, Wednesday, Thursday at 7, they'll be back to dispossess.
The constables actually will count the hours.
Yeah.
Generally, the marshals will consider it 3 days exclusive of the day of service, but the constables will literally count hours and count to 72. And if you've asked the constable to expedite a proceeding for you, they will generally accommodate, for you being the landlord's attorney, generally accommodate and count 72 and be there on the 73rd hour.
Promptly.
Does this program extend to the towns at all?
No.
Just Buffalo City.
Okay.
Just Buffalo. So the two bodies of law that you'll hear most about are the Real Property Actions and Proceedings Law, and I'm just going to say RPAPL, and the Real Property Law. But the RPAPL dictates most of the filing and pleading requirements. So, and the most common type of eviction proceeding is the non-payment proceeding. The tenant didn't pay the rent, followed by the holdover. The lease ended, or the month-to-month tenancy ended, and the tenant is holding over, they're still there. There are other kinds of cases that you'll encounter, and I'll talk about them a little bit later: illegal use, post-foreclosure, and there's a whole body of law, or a whole section of the RPAPL that talks about evictions where there's no landlord-tenant relationship, and we'll get into that a little bit later. But I'm going to start with general filing and pleading requirements, and you actually have a handout.
Which is mine.
No.
It's the